Hi, good afternoon, everyone. Thank you so much for having us here and allowing us to speak on this very, very important and I think something which is going to really rule the world in the coming few years, which is AI. And when we talk about artificial intelligence, it's very important that we also align it with IPR, which is intellectual property rights. Because at the end of the day, we have been seeing artificial intelligence in almost everything around us, whether it is, in fact, even to the extent of arguing a case as a lawyer in a court of law. So that's how far AI is really, taking its place. And when we talk about IPR and AI, we realize that there are so many things, there are so many aspects in terms of, ownership, authorship, how to differentiate the human intervention from AI, and so on and so forth, that it's a very vast topic, of course, something which may not be possible. We were discussing it may not be possible to cover in about 30 minutes, but what we are today looking at is to understand the basic underlying concerns and what we are looking at in terms of, protecting IP, especially for the authors or for someone who's created. And with that, I think I'll start the panel with Mr. Malik. Mr. Malik, what are your views on IPR when it comes to AI and intervention of AI? So if you could please share with respect to copyright and with respect to patent. So please start with anything with respect to copyright.
You have actually rightly mentioned that the copyright is at a intersection with the AI these days. Traditionally, it was not the issue regarding the computer-generated programs and the creativity, because it was just means of tools like pen, paper, paint, and brush. So these are the normal instruments which used in the creative work. But in the era of AI, the whole dynamics and there is a shift in the paradigm shift in this area. Now, the software developer is only inputting the algorithms and codes, right? But the system, artificial intelligence, generative AI system is automatically developing the creative work with very minimal human interaction, right? That makes the difference, where comes the dispute, whether or conflict we can say, whether it is the AI which has generated, software developer is the owner, or the human which has interacted with that is the owner of that thing. I have seen one series in Guilty Mind on I think in Prime, where it has dealt with a very good question, where the AI has generated certain music, right? And the case was filed by the music director that it was copyrighted. Right, then in that case it was a series, so the court ordered that the human intervention is required. So it has not granted anything to the AI owner. But if you see in the other jurisdictions also, I think it's only the UK which is giving the right to the AI, and other jurisdictions are still
China maybe.
And China also, and others are only dealing with the human touch, right? And there is one commercial aspect to it. It's very important that if suppose the music developer through AI has developed a software or a music program, right? He has spent millions of money invested there. And if he's not getting the right, then what would happen to that? Then how will the innovation will carry on? So on this conflict, I have written one poem. If you allow, I will just narrate that.
Sure, please.
In the realm where thoughts take flight, AI's creations a brilliant light. Yet amidst this blaze of innovation's fire, copyright's dilemma, a tug of dire. AI's creations born from codes and streams, but whose right reign in these innovative dreams? Individual sparks, their creativity's glow, clash with AI's outputs, a conflict to show. Copyright's embrace, protecting mind's yield, but AI complexity, a new battleground field. Whose ownership stands in this tangled wine, where AI's prowess meets the individual's design? A dance of law innovations fight, balancing rights in digital light, a bridge to build, a path to find, where both AI and creators' rights entwine. So
Wow,
that's
wonderful.
the poem I have written on looking into the complexity.
Absolutely.
And this, of course, I should give the disclaimer that I have taken the help of AI in writing this. And when I checked with the AI whether who is the right owner, at first instant it said it's the owner is the software developer. When I challenged as a lawyer that it's because of my human intervention, it has been on the picture. Whether you have given the same result to other person, it said no. It's the unique, only given to you, and it will be only used for you, and so you are the rightful owner.
Wow.
That's the AI version.
So we have an author here in terms and beautifully, I think, captured. I think all the aspects of AI with respect to IPR that we were discussing even before the panel is what you've captured in the poem very well. So moving on, ma'am, when we talk about, so sir, of course, touched upon a few aspects of author. But when we actually talk about the authorship of IPR, where there is an AI intervention, what are the issues that we can come across? So we were also discussing duration, and we were discussing those aspects. So if you could throw some light on that. So copyright, so of course copyright where there is an AI intervention, and the aspects around it.
Sure, thank you, Petal, and good afternoon, everyone. So as beautifully written, and with the help of AI, I'll take that conversation forward, because that's exactly is the issue. Now, AI is machine intelligence, and copyright conventionally was provided to human intelligence. Now, we are going to discuss that ownership will vest with machine intelligence or human intelligence. So we have lived an era where computer was aiding to your performance or to the output. Now we are in the era where artificial intelligence is having intelligence, is capable to react, respond, communicate with the environment, and give you the analysis and also analyze the data and give you the output. Now therefore there is a conflict of whether machine intelligence will give the rights or whether the human intelligence is yet required. Now, you read a poem and you said that you are the author or the software developer is the author. Now, the question which arises, and I'm a lawyer, so I'll take a step back, whether it is original. That has to be answered. So what is originality? So now again, there are two extreme views. For example, India, UK, Hong Kong, they take sweat and brow test, where originality has to be your labor, which I think you will qualify because you have given some prompts to the AI tool that I want this and these are the challenges, I want it in this manner, whether it has to be rhythmic or not, length or choices of words and so on and so forth. And vis-a-vis that, there is another view, EU view, where the test is that it has to be human intellect. And human intellect to the extent that, you have written some concept originally and then machine has helped you to kind of convert it into something. Now that's the struggle the whole world is grappling with when it comes to AI. Now, if it is an original work, now the question arises that the prompts which you have given, is the prompt, if given to the machine every time the same prompt, whether it will give the same result. If it will give the same results, then probably your prompts were so specific in terms of parameters that only you could have arrived at it. And this is not what I am saying. This is the recent judgment from the China where there is a case Li versus Liu, where one person, after giving 150 prompts, which was super specific, super technical in terms of what he wanted to be created, and every time you give 150 prompts, the same artwork will be created. If that is of that extent, then it will be kind of some evidence that you have used your human intelligence and fed in the machine intelligence to create something, and that will probably cross the threshold of originality, and then probably you can ask for the authorship. Now the authorship has, just one more minute, authorship has two aspects of it. Authorship cannot be by a machine for two reasons, because as we all know, the duration of AI is after the death of 60 years after the death of the author. Now, if the machine becomes the author or the owner, machine is never going to die. So how long it will be? So it has to be a human being who will be the author and who can be the owner of the copyright.
But
Right.
I just differ on that. That why when the idol in a temple can file the writ petitions, and why not computer can be said as the owner of the machine?
Yes.
Not my software, not myself who created the things. And one more thing is there that just like machines and a human works on the neural network, right? So we are also. If I'm not writing a poem with the help of AI, I'm writing of my own. Even then, I have read somewhere some things. Then I'm creating it. And the same way, artificial intelligence is doing the same thing through the neural networks, right?
I
It's
think
the
that
same.
is that is the whole point of debate, whether whether the author can be in machine at all. Because when we were also discussing, there is China who allows protection in terms of AI created copyright works. But when it comes to US, they are completely with a very different opinion. They state that only if we are able to differentiate, and rightly so, Mamta said, that only if you are able to differentiate between the human intervention and the AI intervention is when you are able to, get a copyright. Otherwise, you can't. So moving on, Amit, if you can throw some light on. So we spoke about the work that has been created, and with AI intervention, or even when it is whether it is patentable, or let's say copyrightable or not, or protected for that matter. What about the authenticity part of it? So when there is an end product which has come, how do we understand and really take forward the authenticity part of the product? Throw some light on that.
Thank you, Petal. So you see, AI, whatever AI is generating today, is something still in dispute to have that authenticity to use it to get the final proper result. Like if we are, like ma'am said, we in litigation, if we are using some arguments which we have framed using an AI, there's a recent case which happened in New York, and they used that judgment, the arguments and the framing, and that they used it in the evidence in that matter. But that was not acceptable. That could not be taken up to use or to put a final judgment in that matter. So authenticity is still a question which is getting explored. Now that we don't have the exact laws which we should to have the concreteness of what we have derived from an AI, we are looking into the different aspects, how we can use the data which is produced from AI to probably simplify what you're trying to achieve, but not to the extent that it can be relied upon, so that tomorrow if something has happened because of probably a negative situation which has arise out of what AI has generated, you cannot pinpoint will it be the author, will it be the person who has given the prompt, or will it be the author of the software, the AI software which has made the situation.
Right. And also, Mr. Tandon, to understand, so when there is a product, it has been created, or a work which has been created, and let's say if it is through an AI intervention and receives also, a protection, what about the infringement part of it? How is that protected? So if it is infringed, who is the author first, and how to protect infringement with respect to any AI created work?
Yeah, thanks, Petal. I think your question before to Amit was really the question which needs to be answered, and
Sure.
the second issue which needs to be answered is who is the author.
Right.
Because if you are able to come to a conclusion as to who is the author, then of
Correct.
course infringement issue will be answered
Correct.
straight away.
Correct.
Authenticity, I wanted to just add that ultimately when we give a prompt on this AI tool, what kind of material AI is going to use, we are not aware. Is it going to use a copyrighted material of somebody? Is it going to use a material which is non-copyrighted? Or is it going to use a material which is completely in public domain? So we are not aware. Now, if I claim authorship to that particular document which has been created through that AI, of course the infringement will lie on me because I am somewhere responsible. So once the question of authorship is answered, infringement is answered. The second issue, according to me, is the period which you also spoke about, that how do you consider AI to die? AI will never die. AI will always remain there. So are we going to bring in the concept of machine in the laws, or we are still going to continue with the laws which we are continuing today?
Right.
I personally feel that at the moment, we really don't know where we are headed.
Right.
The world is grappling with it. The only regulation which we've seen till now, which is far from intellectual property, is in the EU a few days back, which also talks of how users should make use of that AI. It doesn't talk of AI using these copyrighted materials, etc. So I think as a world, we are far from developing those laws, though we've developed that technology. So of course, this is the hottest topic. I also don't have answers at the moment. But yes, these are issues: authorship, infringement, person or machine, originality, non-originality, whether there is originality in giving prompts, whether there is no originality in giving prompts.
Right.
All those issues are there which will have to be answered,
Right.
really.
Right, of course.
And one last thing, I totally disagree on one fact, that the AI will be able to take over court work. I don't think
I don't
so.
think it can, because
There are a lot of emotions involved there, and AI has no emotions.
that, as well as the skill. I think that skill part, AI can never,
That's right.
take over.
So I just want to add
Yes,
here
ma'am.
that, the human being is blessed with inherent cognitive faculty, whereas machine is a trained, intelligence. So there is a huge difference, and that can never be taken away. And just to add what Kunal just said, that, for infringement also, the data, input data and the output data, we have to understand it very well. So if input data is legitimate, which means if it is taken from the source which is publicly available data, non-copyrighted, and if you are then generating something, probably you will not be responsible for any copyright infringement. But what if your input data itself, the AI tool which you have used, itself has collected such data which are infringing copyright data, and you are not made aware of that, and you are using, who will be responsible for that? Software developer, the AI providing tool machine, or the user who has used? And this is what the question the whole entire EU is grappling with, the legal framework, the ownership and the responsibility associated with handling AI development or AI as a tool or by a user. So this is going to be a very interesting era, but all said and done, we can't avoid, AI is there and we have to embrace it.
Absolutely. And ma'am, if you could maybe also throw some light in addition to this to the fact of, so we all know that copyright really attracts royalty aspect to it. So how is that going to be dealt when it comes to any AI created work?
A very interesting question, because IP we all know is what? It is a potential to exploit and generate revenue. IP is a tool to generate revenue. If the underlying work or if the creation is not rewarded, then there is no IP and there is no interest in IP. So therefore, when we are talking about either of patent or of a copyright, who is going to take the award, or who is going to take the royalty or the reward for the work generated? That's the question which we need to answer. So if it is going to be a machine, and whether we are going to, for example, I'll just give a quick example of this Dabas case, which has gone to US, to Australia, to UK, and everybody said that it is the natural person who can be an inventor in terms of the patent I'm talking about. And only Australia said that, okay, it can be a natural person, but in terms of who can receive the reward, who will have the person who can secure because it can't be a machine. So the person who is owning that AI or owning that software can receive the royalty of the invention which is being exploited. But in terms of copyright, it's more complex, because we are talking about copyright. There is one work can have underlined work. For example, there is a musical composition which can be a lyrical word. So now there is a lyricist who has created something, who has written the song. Now there is a composition, but when you are playing the music, there are so many underlined work, and you have to give royalty to all those people who have created the underlined work. So how are you, if you make AI as a author of the book, how are you going to distribute this royalty to the people whose work has been collected and fed in the machine to create a new work? So are you going to recognize and give those royalty to those underlined work, and to those authors whose work has been fed in the machine to create a new work? So that all that is going to be a very complex issues, and I think internationally a lot of work is going to create that framework, and the ownership and the liability and the compliances issues that you have to undertake and disclose as to which are the work which you have fed, what data you fed in the machine. If the data is copyright free, then probably you can use it. If the data is not copyright free, you will have to first pay them before you are feeding this data in your AI machine.
So I think at the end, the only answer we need is who is the author.
Who is the author?
Yes.
I
If we
think
find an
who is the
answer
author,
to that.
who is the creator? I think if that is clarified, then a lot other things are also crystallized further. So, sir, from you, maybe also closing remarks and some thoughts on the aspect of disclaimers. So, when it comes to, let's say, when we were also talking about, ma'am was throwing light on the aspect of whether protected or a copyrighted work is being used. So what is the input that is being generated, and whether it's a patented or a copyrighted or protected work that is being used in creating your new work or not. So do you think that AI also needs to have that kind of disclaimers, and that will probably help us to create a work which is let's say not going to attract any liabilities when we are creating a, let's say, copyrightable work?
Actually, all these issues seems that a human has a fear. While they have created AI, but now they are in fear what will happen to them only, right?
Yes.
I don't think God, while making human beings, had such kind of fear, right? So practically, if we say, of course, disclaimers are there. AI is being linked sometimes as a beast, sometimes it's out of a genie bottle, and something it's cannot be controlled, and all things are there. But still, I feel the AI itself will give the answer all these to these questions, the queries which you are having. I am confident that the technology will find the pave way. Of course, there is a need to have the balanced approach between because nobody should be get hurt because of that. So everybody will get their dues in the due course of time.
Right.
So,
right,
Petal, I
absolutely.
think
So-
the answer. I'm sorry.
Yeah. So I am just saying that the rise of machine is here, not as a conqueror, but as a creator. Someone has said, I have not said this. Disclaimer.
So I think
Thank
the
you.
answer to your question lies on the fact whether we have the care and diligence to
Absolutely.
be exercised in
While
respect
we're creating, yes.
while
Yes.
it is being created. Now,
Yes.
care and diligence is required to be exercised in certain areas. It is not required to be exercised in certain areas. Like let's say defamation law. Care and diligence may not be required when you are airing a news. You just to follow and stand there and say, I say this is the truth. But care and diligence may be required in AI creation, in which case disclaimers will not work.
Yeah.
It can't be that I disclaim that this is right or wrong. Because
Correct.
I need to be careful and diligent.
Correct.
So it'll really depend as to how the laws develop.
So even if it is
around.
there, it may not be of any help.
May not be of any help.
Absolutely. So Amit, maybe some closing remarks from you, or maybe we'll go one more round if there's time. What is that one bane and boon that you were talking about when it comes to using AI in, let's say, any IPR?
So you see, like I said,
One each.
yeah, so the boon is you can use it to simplify your stuff, to simplify an answer, to probably, in fact, I was just telling Kunal that we can feed it to AI to ask him who is the author to you. It might not name you the author, but it will give you an answer. But the boon is simplifying. Bane is you can't use it. You can't use it to actually give an answer to where you are representing.
Or let's say you can't even rely on that
Rely
answer
on-
completely,
yes,
100%.
you can't rely on that
Yes,
answer completely.
Yes, absolutely. It may have made life simpler
Simpler.
in some manner, but at the end of the day, you need to, put your, what Mr. Tandon said, skill and diligence at all times. Closing remark from you, Mr. Tandon.
Bane or boon?
Yes.
I think surely not a boon, because human mind will surely become very lazy.
Absolutely.
We as human beings tend to find very, very short methods of producing results. I can give you one very small example. When we came into the practice, we didn't have search engines like we have today, SEC Onlines, etc. So the research used to happen through quintessentials or the 10-year digest. We used to go under those topics, look for those judgments, and for latest judgments, we would actually go to quintessentials and see whether under that particular act कोई judgment तो आई नहीं है कि नहीं. आज क्या करना है? At the click of a button on Google, I can get कि कल judgment कौन सी pass हुई थी. So the fact that I'm trying to say is that you are not reading anymore. You're not enhancing your knowledge. You're just going, typing few keywords, getting that judgment and reading that judgment, and that's it. But you're not reading 10 different judgments. So surely, my view is it's surely not a good thing. But yes, technology is going to help us somewhere. Let's see how it goes.
Ma'am, very quickly.
Yes, very quickly. I disagree completely, and I'm sorry, Kunal. It's a boon, and nobody can deny it, because it's a progressive time, and AI is now being, jokes apart, AI is now being used in education, in training, in medicine, in medicine. I mean, every walk of life, everything we are talking about, it's AI related. So it's definitely a boon. It's a new future. We need to kind of be not lazy enough, but learn it quickly.
Ahead of it.
Yeah,
I think we really
it,
need
yes.
to be ahead of it.
Yes.
Sir, Bane or boon? Quickly.
It's always a blessings actually to have AI also. It's only the God gifted. So we should use it diligently and with care.
I think the moot point is to be able to use it and to be able to really make the most of it in the most appropriate manner, and without getting lazy, and with a lot of precautions. So thank you very much. Our time is up, and so are we. Thank you. Thank you so much.